My main clarifications in my speech are on the definition of sex as it is set out in clauses 8c and 10 of the bill. The definition includes biological characteristics from birth and after the completion of sex reassignment procedures. What it clearly leaves out is discrimination on the basis of gender identity and sexual orientation. A person's gender identity and expression, as well as their sexuality, are a part of who they are. They are not lifestyle choices that can be changed on a whim. While the proposed law supports individuals who have undergone sex reassignment procedures, it seems to ignore the reality that the transition from one gender to another is something that happens over time and involves more than just surgical procedures. Sometimes individuals may not even choose to undergo surgical procedures. This is a complex process and it involves medical, psychological, and social aspects. Individuals in the process of transitioning or who choose not to surgically transition can also be susceptible to discriminatory practices in the workplace. Members of the arts community who are also members of the LGBTQ+ community have told me that they feel very concerned about the additional exclusions at Clause 10.2 of this bill. These exclusions could have the effect of reiterating the fact that characteristics which are relevant to the community will resolutely not have the protection of this law. This could in fact signal to the wider population as well as employers that discrimination on the basis of one's sexuality and gender identity are not sufficiently serious or valid concerns. Taken to an extreme, some might interpret this as the government condoning this kind of workplace discrimination. It could also inadvertently signal to employers that such discriminatory practices will go largely unpunished. Now, this is not the only place where we see a similar kind of signaling in the bill. At the explanatory note on Clause 17, there is a statement there that when an employer dismisses someone on the ground of the race of that person's husband, this will not be considered as discrimination under the new proposed law. Now, speaking as someone who actually does have a husband of a different race, this was slightly alarming for me to read in the bill. Now, I understand that given the prescriptive approach that's been adopted by the government in this piece of legislation, certain lines have to be drawn and clear positions have to be elucidated. To put it another way, when lists are made, there will always be questions on why certain things are included and others are left out. To an extent, this is just something inherent in the structure of the legislation that has been adopted. I think most members of the public and members of this House can understand that. But that being said, it is important too that the specific wording in the bill does not send out unintended messages that seem to actually endorse certain acts of discrimination. To this end, it would be good if the Minister could explain the basis behind the explanatory note on Clause 17 and on how members of the public are expected to interpret it. Now, yesterday I note that the Minister has explained and mentioned that the acts that are described in the explanatory note would be caught by the TGFEP and just not by this bill. But notwithstanding his explanation, I would like to ask, was it then necessary to include an example like this in the bill? Could the explanatory note have been clearer that such acts are very much discriminatory, even if they are not covered by this bill? Now, coming back to the definition of sex, very recently this House debated the repeal of Section 377A of the Penal Code. In connection with this, many members on both sides of the House reiterated their views that discriminatory behavior towards people on account of their sexuality should simply not be tolerated. So I do not think at all that the government intends to send the message to the LGBTQ+ community that discrimination against them is in any way permissible. I was also heartened to hear the Minister yesterday say that no one would be turned away with their workplace grievances just because they do not happen to be covered by the bill. The Minister seems to have taken a very strong approach towards ensuring that tolerance is displayed by employers and by members of the public. So I hope the Minister takes the opportunity during this debate to assure the LGBTQ+ community that their rights in the workplace will be protected, regardless of the wording in Clause 10.2 of this bill. I note from a Straits Times article in November 2024 that the protected characteristics set out in Clause 8 of the bill account for 95% of workplace discrimination complaints which have been made to MOM and the Tripartite Alliance for Fair and Progressive Employment Practices, or TAFEP. On one level, this is a very logical way to proceed. However, we should not forget that it is also possible for discrimination to exist in the absence of formal complaints. The report, Discrimination and Harassment in the Workplace, the Lived Experiences of Singapore LGBTQ+ Individuals, raises some notable feedback. According to the report, which was based on a survey of around 700 respondents, almost one-third had experienced at least one form of discrimination in the workplace due to their sexual orientation or gender identity. Close to half of the people surveyed reported some form of harassment at the workplace. However, the report also noted that among the participants who had experienced discrimination and harassment, only a very small number had actually reported their experiences to their respective companies, to MOM or to TAFEP. Some of the reasons for this included a fear of retaliation, social stigma, and the expectation of little support if reports were actually made. We can see how this fear creates a harmful loop. Victims remain unheard, leading those in positions of authority to mistakenly believe that there are no issues of concern. As a result, protections remain inadequate, and those facing workplace discrimination continue to suffer quietly. So my questions for the Minister are these. First, did the Ministry take into account the research and feedback from the ground which indicate that LGBTQ+ individuals tend to underreport incidents of workplace discrimination and harassment? If so, how then was the decision arrived at to exclude sexuality and gender identity from the protected characteristic of sex? Secondly, how will the Minister ensure that employers do not discriminate against employees on the basis of their gender identity and sexuality, given that the proposed law explicitly excludes these two traits? Is the Minister able to provide any assurances that discrimination against employees on the basis of their gender identity and sexuality will not be tolerated by the Ministry? For example, will the Minister consider including specific protections, templates, and resources for LGBTQ+ individuals through TAFEP and the Tripartite Guidelines on Fair Employment Practices, or the TGFEP? Now, the Minister yesterday alluded to updates being made to the TGFEP, so I look forward to hearing his further explanations and clarifications later. I would also like to ask if any measures would be put in place to ensure that reporting systems are accessible, trusted, and effective for LGBTQ+ persons. For example, would the Ministry work with LGBTQ+ groups on the ground to conduct training for TAFEP and other frontline MOM staff to ensure that cases of discrimination are dealt with seriously and professionally, and to encourage reporting of such incidents when they do take place? Finally, I would like to ask if there are any plans for the law to be re-examined at a specific point in the future, and to consider whether the exclusions at Clause 10.2 may be removed or amended. MOM has indicated in its fact sheet on the proposed bill that tripartite partners will review the exemption set out at Clause 4.1 of the bill in 5 years' time. If so, will a similar reconsideration of Clauses 8C and 10 also take place? A number of countries, including the United Kingdom, Australia, and New Zealand, have codified provisions against workplace discrimination based on gender identity and sexuality. So if we in Singapore were to change our position in future, we would certainly not be alone in doing so. Mr. Speaker, notwithstanding my clarifications, I stand in support of the bill. Thank you.